Now, the other word we need to properly define is contempt, which again the Free Legal Dictionary defines as open disrespect or willful disobedience of the authority of a court of law or legislative body. I'm sure we've all seen a movie or a TV show where someone is charged with contempt of court, the disrespect or disobedience of a court. If you are given a court order and you disobey it, you can be held in contempt of court. If you treat the court with disrespect, the judge may hold you in contempt of court. Of course, there are some judges who abuse this power, holding people in contempt for disagreeing with them or for challenging a decision. Now, hopefully those instances are rare and dealt with legally. The question still comes up though. Why is disrespect or disobedience of a legislative body included in the definition? Courts are part of the judicial branch, and the judicial power of the United States is limited to trying cases and deciding controversies. Should someone fail to appear for a court-related subpoena, they are denying one party of their rights, either to confront witnesses against them or to compel witnesses for them. Either way, a legislative body is, by definition, exercising the legislative power of government. Congress's job is to create laws, not to enforce them. And since we the people hire them, why should we be legally punished if we disrespect or disobey anything other than a law that follows the Constitution? Let's start by looking at the constitutional issues with subpoenas in general. See, subpoenas compel the attendance or production of evidence, but that's a violation of the Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." Compelling attendance is a seizure. No one, not law enforcement, not Congress, and not even a court, can seize you without a reasonable cause. Remember, a subpoena is not a warrant. The warrant clause of the Fourth Amendment states, "No warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." A warrant establishes reasonableness for the seizure. It must be based on probable cause and supported by oath or affirmation. These are important because lying under oath or affirmation is itself the crime of perjury. However, there is no requirement of probable cause or legal jeopardy for issuing a subpoena. There's not even a requirement that there be a reasonable articulable cause to issue a subpoena. So a judge, attorney, or other duly authorized individual can issue a subpoena merely because they think someone's evidence or testimony is valuable to them, without any jeopardy of charges of criminal misconduct. Take, for example, the case I wrote about recently about warrantless searches, where the New Jersey Attorney General issued subpoenas for private information without any apparent legitimate cause. While there is a legal action to suppress the subpoena, I don't believe there's even a crime on the books that the AG could be accused of. It's not just unreasonable seizures. Remember, subpoenas are used to collect evidence without a warrant, making them not just unreasonable searches, but violation of the Fifth Amendment self-witness clause, which reads, "No person shall be compelled in any criminal case to be a witness against himself." The language of a subpoena may compel a witness to provide evidence that would be a witness against them, all without any probable cause or testimony under oath that there was a good reason for it. These subpoenas also violate the due process clause of the Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. Attorneys and courts claim the power to deprive people of both their liberty and the property they have in their bodies, documents, and other evidence without any form of due process, which is defined as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. That means the whole process of issuing a subpoena is constitutionally questionable at best. So where does Congress get the authority to issue them? The only place Congress is authorized to compel anything is Article 1, Section 5 of the Constitution, which reads, "Each house shall be the judge of elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide." Congress can compel members to attend, but that's it. So Congress could issue a subpoena to a member to compel their attendance of session, but not the general public. Now, contempt of Congress is defined as deliberate obstruction of the operation of the federal legislative branch. But what if the obstruction is of an operation the Congress is not legally authorized to perform? Remember, Congress is the federal legislative branch. Their job is to write laws, not to investigate crimes or to intimidate people into compliance. Congress can hold hearings, but they must be for some legitimate legislative purpose. Was Congress holding hearings to consider impeachment for former President Bill Clinton and his wife, former Secretary of State Hillary Clinton? Were they seeking information for some new legislation? Or was this just another political hit job, abusing their office to attack political opponents? In other words, what was the legitimate legislative purpose for the hearing Congress wanted the Clintons to testify at? And what was their legitimate reason to compel their attendance? Let's assume that Congress had a legitimate legislative reason to seek the testimony of these two individuals. Where's the due process? Where's the probable cause or the reasonable suspicion? How is it willful disobedience when the subpoena appears illegitimate? How is it disrespect for the authority of Congress for one to exercise their rights? Rights, by the way, protected by the very Constitution that every member of Congress took an oath to support. Now, subpoenas have their legal and legitimate place in our judicial system, not our legislative system. Courts can compel the attendance of witnesses, but to place legal punishment without a warrant is a violation of the Fourth and Fifth Amendments, because there is no due process or requirement of reasonableness attached to the subpoena. Could the process for issuing subpoenas be brought into compliance with the Constitution of the United States? Sure. Require some documentation of the reasonableness of the subpoena. In my case, a simple statement that I was being called to be a witness either for or against the accused. Now, under the Sixth Amendment, that would make the subpoena reasonable. Also, removing the criminal contempt of court language, replacing it with using the language of the subpoena as evidence of the probable cause for a warrant. That way, a judge should at least review the subpoena to make sure that it didn't violate the due process of law. Lastly, since Congress is the legislative branch, not the judicial branch, any subpoena they issue should request attendance, not compel it. Unlike courts, which have a duty under the Sixth Amendment to provide witnesses, Congress has no such power to deprive people of their liberty and property without due process of law. If they wish to compel attendance or the production of evidence, they need a warrant. The executive branch, which includes law enforcement power, needs to provide at least a reasonable, articulable suspicion of a crime before they can detain an individual. Shouldn't Congress be held to the same standard? To me, this is another example of the legal system drifting far from the Constitution, generally through its own ignorance, because it apparently is not taught in law schools. To compel someone's attendance without due process of law is not only a violation of the Constitution, it's a federal crime. 18 U.S.C. Section 242 says it's a crime to deprive someone of a right protected by the Constitution of the United States. Now, you may not be able to hold members of Congress accountable. That doesn't mean there's not a crime committed there. And that's a big concern, because I've seen it used by both parties as political hit jobs against their opponents. Today, it's the Clintons. Yesterday, it was attorneys general. These are examples of, we're going to compel your attendance though you have no legal authority to do so. It's actually a violation of your oath to try to compel attendance without due process. You have to have a reason. You have to show that reason in court. You can't just make it up. But most people don't know that. So most people don't even question a subpoena. Again, when I received mine, I looked very closely before I determined whether or not I was going to fight it. Again, since it was dealing with a witness in a court case under the Sixth Amendment, to me, that gave them reasonableness. There was a due process to be fulfilled. And I didn't have a problem with that. I had other problems with the subpoena, but that's a story for another day. The point is, by knowing your rights, maybe you can push back on some of these if you happen to get a crazy subpoena. Again, not just from Congress, but you have to look at a subpoena from a state like like New Jersey. Where's the reasonableness of this search for information, of compelling people to provide a witness against themselves? It's crazy. And it really disappoints me that our legal system is so constitutionally ignorant. But that's our challenge, isn't it? To take it from a constitutionally ignorant body to a constitutionally literate body. In fact, I want all the American people to be constitutionally literate. That's why I started the Constitution study. To not only take what I've learned, but to share it with as many people as possible. So if you can share this content, that would be wonderful. Not just this episode, my other articles and episodes and my news feeds. I've got mailing lists that you can sign up for to get my weekly article and video, or to get the news I find interesting, or anything else. There's lots there. You can find it all at constitutionstudy.com, and I hope you'll join us in not only consuming this information, but sharing it. If you'd like to support the work we're doing, you can do so with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. And they're great because they share our values. In fact, they take a portion of every dollar and they share it with organizations like the Constitution Study that are fighting to defend your rights. Just go to patriotmobile.com/constitution and find a plan that works for you. See if you're eligible for a discount. Everyone from first responders to families with multiple lines can get a discount. And when you pay your cell phone bill, guess what? You're helping to support the Constitution Study. As a special bonus, use the promo code Constitution at checkout. You'll get your new line activated absolutely free. Support the work that we're doing here every time you pay your cell phone bill by going to patriotmobile.com/constitution, finding a plan that works for you, and then don't forget, use that code Constitution at checkout to get your new line activated absolutely free. Most of all, I hope you'll come back. I hope you'll share, and hey, maybe come back with a friend or two the next time we meet for the Constitution Study.